the private plan application process. We are going to record this webinar so you can access it through the Paid Leave Authority's YouTube link. And we can also share the slides if anyone is interested. I'm going to start sharing my screen. We'll go through the private plan process, and then we have plenty of time for questions. If you do have questions, please put them into the Q&A function so that we can keep track and make sure we're getting all of the questions answered. All right. While I'm sharing my screen, it won't be possible for me to see if anyone is raising their hand. So again, just please put your questions in the Q&A. We'll have plenty of time to address them in the second half of the hour. Thank you for joining us today. As I said, my name is Erin Choquette, and I'm the General Counsel for the Connecticut Paid Leave Authority. Prior to joining the authority, I worked for 14 years at the Department of Administrative Services, which is the agency that handles all of the back office functions for other state agencies. In my career prior to joining the state, I was an attorney handling insurance matters and employment matters, and I have spent a lot of time over the past 20 years in state and in private practice working with FMLA issues. The Connecticut Paid Leave Authority is a brand new quasi-public agency. We were created by Public Act 19-25, the same law that created the Connecticut Paid Leave Act and modified the Connecticut FMLA. The purpose of the Connecticut Paid Leave Authority is to fill the gap between, or that exists because employers have the, employees have the right to take job protected leave for various reasons, but most employees have very few resources to receive income while they're taking those job protected leaves, which means that many can't take the leave. So the goal of the Paid Leave Authority is to provide those employees with a path to accessing those paid benefits, and also to provide employers, administrators, and healthcare providers, really everyone involved in the claim process, with helpful tools and useful guidelines so that they understand their roles and can fulfill them. The Paid Leave Authority is responsible for engaging in outreach and education, which is one of the reasons we do these webinars. We also have to stand up the Paid Leave Authority itself and all of its component parts, including employee contributions and the claims administration. So we're developing those policies and procedures. As I mentioned, we handle employee contributions under the statute. Employees are required to remit 0.5% of their wages to the Paid Leave Trust. The employees fund the trust, but the employer is responsible for actually passing those contributions to the authority through their payroll processes. So we receive those contributions and administer the funds. We will also, beginning in 2022, administer claims for paid leave benefits. Benefits are not available until January of 2022, and we are in the process of negotiating, selecting and negotiating with a third-party administrator who will help us actually administer the claims so that employees will have access to benefits in a timely fashion. And the focus of today's webinar is our fifth responsibility, which is to approve and audit private plans. We'll focus on that today. If you have questions about the paid leave program, Connecticut FMLA changes, we do offer other webinars that really delve into those more general topics. So please check us out on our website and on YouTube to find those videos. Just some basic information for you while you're understanding what the obligations are. As I said, we were created by Public Act 19-25, which took effect in July of 2019. The board was actually convened for the first time in October of 2019. The first responsibility of the board of directors was to hire a CEO who came on board in March of 2020. And since that time, we have been moving like crazy to get our website up, which went live in September, to allow employers to register, which went live in November, to make sure that employers and employees understood their contribution obligations, because the obligation to start taking the deductions began on January 1st, 2021. And the contributions need to be remitted on a quarterly basis. We also stood up the private plan policy and the application process, and have been reviewing applications for private plans for over a month. And we will continue to do so. As I mentioned, benefits will be available beginning in January of 2022. We expect to have our claims administration process up and running in December, so that people who know that they will be out in 2022 can submit their applications in advance. Just a quick overview of the Connecticut Paid Leave Program. As I said, most all employees working in Connecticut for a covered employer are required to contribute 0.5% of their covered wages. The wages are basically the same wages you use when you determine your employee's FICA obligation. Those wages have to be remitted to the Connecticut Paid Leave Authority to be put in the Connecticut Paid Leave Trust. The only exception to this obligation is when an employer receives permission from the Paid Leave Authority to offer their employees a private plan instead. If you are not a private plan employer, meaning if you are just participating in the regular Connecticut Paid Leave Program, you will remit your employees' contributions to the authority, and those employees will be able to apply to the authority for income replacement benefits, assuming that they have earned at least $2,325 in their highest earning quarter when you look at the first 4 of the 5 most recent quarters preceding their request for benefits. They also have to have a qualifying reason for leave. You don't just get the money, you have to show that you are out of work for a covered reason. Employers who receive approval to offer their employees a private plan will administer their employees' claims for income replacement benefits themselves, instead of having the employees come to the Paid Leave Authority. So I said most all employees are covered under the program. There are a few exceptions. So who is covered? Well, it's really broad. It's any employer who has 1 or more people working in Connecticut. So this includes not-for-profits, it includes private sector employers with unionized workforces. It includes entities who may not be subject to unemployment obligations, but they have employees working here in Connecticut, so they're covered. We also allow sole proprietors and self-employed individuals, so business owners, basically, to opt in if they want to. This is similar to workers' compensation, where it's a requirement for your employees to participate, but if you're the business owner, you're not required to participate, but you are allowed to choose to do so. If you choose not to do so, that's fine. You don't have to do anything. You don't have to tell us, you just aren't in. There are a few employers who are not covered. Basically, these are the same employers who do not receive the protection of the Connecticut FMLA, and that includes the federal government, the state of Connecticut, except as to our covered public employees, municipalities and local or regional boards of education, unless they have covered public employees, and non-public elementary or secondary schools. A covered public employee is defined by the statute. It includes the following. It includes all non-union employees of the state of Connecticut. So managers, appointed officials, elected officials are non-union, and so we do contribute to the program and would be eligible for benefits. Municipalities and local or regional boards of education are excluded from the program, but if their unionized employees collectively bargain to become included, then all of the employees, union and non-union, of that town or board of education would be considered a covered public employee, in which case they would remit the contributions. So if you are not in the category on the right, if you are in the category on the left, you're an employer with 1 or more people working in Connecticut, you have to make sure that your employees contribute to the program unless you receive an approved private plan. So what is this private plan? Well, the statute, specifically section 31-49O of the Connecticut General Statutes, allows employers to apply to the authority to use a private plan to fulfill their obligations under the Connecticut Paid Leave Act. If you have an approved private plan, as I said, you'll be the one administering your employees' claims for benefits. If you're approved, you no longer need to remit your employee contributions to the Paid Leave Authority. You're entitled to use those same funds or a portion of those funds. You don't have to have the same amount. But if you do take any employee funds to support your private plan, the withholding cannot exceed the paid leave program's contribution rate, which is set by statute at 0.5%. It can go down, but it cannot go up. And you can only use that money to support the private plan for paid leave benefits. It cannot be pooled together with your other benefit, employee benefit, or welfare plans. The Paid Leave Authority Board of Directors approved the private plan policies and procedures, and that can be found on our website. If you go to www.ctpaidleave.org and click on the button for I want to apply for a private plan, you'll see all sorts of information about the private plan requirements. And you can scroll down and actually see the full policy and procedures document. Just to summarize the key points, in order to be an approved private plan, the plan must offer the same or better benefits as the public plan, meaning it must cover all the same reasons, and it cannot cost the employees more. The benefit must be at least the same amount and must be for at least the same length of time. It must also cover all of your employees. If you are a multi-state or multinational business, your plan doesn't have to cover everybody, but it does have to cover everyone working in Connecticut. The point is, you can't have a private plan for your executive staff, but tell your sales force that they should participate in the public plan. If you want a private plan, it's got to cover everyone in Connecticut. Also, because the Connecticut Paid Leave Program is designed by statute to be entirely employee funded, which makes it more accessible to your employees when they move from employer to employer. They still retain that access to those public benefits. The legislature felt that any choice to go to a private plan had to be made by the employees because it's their money and it's their ability to go from one place to another. So the statute says that any private plan must be approved by a majority of the employees working for that employer. As I mentioned, the private plan must provide the same or better benefits as a public plan. So it has to provide benefits for an employee who's out for their own serious health condition, as well as an employee who's taking leave to care for a family member who's sick, to care for an injured person who was injured in the line of duty on active duty and military service, to provide qualifying exigency leave, which is leave available if your parent, spouse, or child has been called to active duty. And there's also protection for family violence leave. Short-term disability policies generally don't cover all of that. Oh, and bonding, I forgot. You also get leave to bond with a newborn baby or a newly adopted child or newly placed foster child. Most short-term disability policies will only cover your own serious health condition, may perhaps have some protection for bonding, but many don't. In any event, no short-term disability policy covers all of the same reasons as the Connecticut Paid Leave Act. So if you want a private plan, you have to get a specific plan that specifically addresses all of the Connecticut statutes. There's all of the benefits under the Connecticut statute. A private plan could consist of either an insurance policy or a self-insured plan plus a surety bond. The difference here is who's paying for the benefits. If you purchase an insurance policy, you pay premiums and the insurance company will pay for the benefits. If you have a self-insured plan, you are committing yourself, your business, to actually pay those benefits yourself. For that reason, it does need to be supported by a surety bond, which runs to the benefit of the authority. The surety bond is not what you tap into to pay the benefits. The surety bond is there in case of an emergency where your plan is, you're no longer able to provide your plan to your employees, and your employees are basically up a creek and need to come into the Connecticut Paid Leave Program. We can't just absorb a brand new batch of employees who haven't been contributing. So the surety bond, which is equal to a year's worth of contributions from your employees, is intended to provide that protection, make sure that your employees can participate in our program and that the program remains protected, even though the self-insured plan was not successful. Going back to the insurance policy, it has to be a policy provided by an insurance company that's been approved by the Connecticut Insurance Department. The Connecticut Insurance Department has identified several agencies or insurance companies that can provide policies. I'll give you a list in a moment. We're basically in a two-step process for these private plans. In order to make sure that employers who were interested in providing private plans to employees would be able to do so before they have to remit contributions to the authority, we wanted to get this private plan application process up and running quickly. However, insurance companies have been telling us that they need additional information, both from the Paid Leave Authority and from the Department of Labor, that simply is not available yet, and really would not be available in time for them to develop final policies before the contributions are due at the end of the quarter. So we took a leaf from the process that Massachusetts followed when it implemented its paid leave program and created an interim period. During this interim period, employers can apply for the exemption and receive approval to not remit contributions to us on the basis of a declaration of insurance. If you choose for a fully insured plan, you'll obtain a declaration of insurance from one of the approved insurance companies. If you decide you want a self-insured plan, we do have a form of the declaration of self-insurance that you would fill out and submit that with your surety bond. Under this option, employers commit to supplementing their applications with a final policy document within 60 days of when we issue a final policy filing guidance notice, which will be issued sometime this spring. As I mentioned, the Connecticut Insurance Department has approved a number of insurance companies that can offer you those declarations of insurance and basically offer you insurance for private plans. And more insurance companies are being added every month. So we have this interim period, which we're still in. When the interim period ends, employers will supplement their applications with the final policy documents that they'll obtain from their insurance company, or will update their self-insurance plan documents. And once that ends, we'll no longer deal with declarations, we'll just deal with the plans themselves. Okay, how do you apply for a private plan? Well, the very first step is to register. You have to register whether you want a private plan or not. All employers in Connecticut need to register with ctpaidleave.org. This makes sure that you have your account set up. If you are going to just participate in the public program, the registration enables you to provide all the information you need and we need so that you can remit your contributions on a quarterly basis. If you're interested in applying for a private plan, you need to register, and you can tell us that you're interested because that's where you'll go to file your application. So that's step one. Step two, before you can actually apply, you need to decide if you're going to do a fully insured plan or a self-insured plan. You need to educate your employees about the private plan option, and you need to hold an anonymous employee vote. Once you've done all of that, you'll go back to the account you created at ctpaidleave.org. You'll click on My Account, you click on your business name, and then you'll see a tab that says Private Plan. And there's instructions to follow there. There's some very basic information that we request. You have to upload your plan documents and provide us information about the employee vote. So how do you pick your plan? Well, you either work with one of the insurers who's filed a declaration of insurance, or you can develop a self-insured plan based on the self-insured declaration document. Then you need to educate your employees about that plan, including providing them with the plain language guide. So both the plain language guide and the self-insurance declaration document can be found on our website. If you go to ctpaidleave.org, you click on the private plan tab, and you scroll all the way to the bottom, you'll see a tab for private plan. I showed you that a couple slides ago. The plain language guide is something that I just want to take a moment to explain, because we are seeing some applications where they don't seem to have modified the plain language guide to fit their specific circumstances. That document is a template. Much of it you need to leave as is because it provides all of the legal information that you need to provide to your employees. But there are certain sections that you need to modify, and you'll tell because it's in italics, to make it applicable to your staff. So you need to say who you are. You need to tell your employees if they're going to be required to remit contributions to support the private plan, or if the employer will fund it entirely by itself, or some combination. I've seen employers who say they want a third of 1% to go to the private plan. Some say up to the half. You need to let your employees know who they contact if they need to make a claim. So that's all the information that you need to modify in that template guide. You provide that guide to your employees, and you have to give them at least 2 weeks to review the guide and your declaration so they can understand what they're voting on. Then you need to hold an anonymous vote. That could be a paper ballot if you're a smaller enough employer where a paper ballot is not onerous and your employees are coming to the office. It could be a web-based app like SurveyMonkey or Google Docs. Email is not going to work because it's really hard to be anonymous with the emails, right? So we want you to hold an anonymous vote. And as I said, a majority of your employees must vote in favor of the plan. If you want a self-insured plan, you also need to obtain a surety bond running to the benefit of the authority that's equal to the estimated value of a year's worth of contributions. The surety bond is something you would purchase from a surety insurance company or surety agent. We do have the bond form available, and if your surety company is asking for it, we've tried to make it public to them, but we can also provide it to you. They'll fill it out, you'll pay for it, and then you'll upload the bond with your application. As I said, the plain language guide is available. The template is at Exhibit B of the Private Plan Policies and Procedures, which you can find on our website. If you do make any changes, as I said, it is permissible. It's actually necessary, so you can tell your employees what you're providing. But any information you provide must be accurate, complete, and non-coercive. Your employees must be able to vote as they think is in their best interest, and not because they're worried about what the boss is going to say. The way you distribute the plain language guide and the declaration really should be as efficient and effective as the way you distribute other legally required information. So, however you're distributing information about open enrollment to your employees, however you distribute information to your employees about sexual harassment prevention training and sexual harassment prevention policies, which are you required to do. Whatever you're doing for those other legally mandated information, you should do for your plain language guide and vote information. You have to make sure that all of your employees in Connecticut are given the opportunity to vote. So if you have employees who are out on leave, you have to make sure that they receive the information as well. You can't just say it's available for people who are coming into the office or who have access to your intranet. It has to be available to people who may not be able to access those things because they're out on leave. As I said, the vote must be anonymous, and it must be capable of independent after-the-fact verification. So bringing everybody in and telling them to put their heads down on the desk and raise their hands, which works for third grade, does not work for this because we can't independently after-the-fact verify the vote. We want to make sure that the employees truly understand what they're being asked, and so there's no question about what the language of the vote should be. We've given you the question. Do you approve the company's private plan to provide benefits required under the Connecticut Paid Family Medical Leave Act? Yes or no? As I said, a majority of your employees must support the vote. That means a majority of your employees working in Connecticut, not just a majority of the employees who voted. As I said, if you go to the Private Plan Policy and Procedures document on our website, you'll see the complete list of requirements. It includes things like making sure that the vote is accessible to individuals with disabilities and making sure that you provide it in a way that if you have a large number of employees who don't speak English, that they have access to the documents in a way that they can understand. As I said, when you apply, you're going to give us your plan document, whether that's your insurance declaration or your self-insured declaration, and the plain language guide. We need both of those documents. You'll also need to give us your surety bond if you're offering a self-insured plan. We're going to ask you about the vote, how you handled it, and you need to attest that you complied with the voting procedures. And we do have the right to audit the voting process. You'll also attest that you will comply with the private plan requirements, and if you have an insurance company or a third-party administrator, you'll direct them to do the same. This is just a screenshot of what the application process looks like. As I said, you'll go to your account on ctpaidleave.org. After you've registered, you'll have an account. You'll be able to access it from the top right-hand corner. You click on your account, you click on your business name, you'll see a tab that says private plan. When you click on that, you'll see this. The first thing you have to tell us is if you've got insurance from an insurance company or you're self-insuring, and that'll drive the rest of the application. We ask you to tell us who you're using. We've pre-formatted the ones who are currently approved, but if you have someone who has been recently approved and not in the drop-down list, you can add that. We ask for some information about your policy, and then we ask you to upload that plain language guide and your declaration of insurance. We know that you may not have your final policy document yet, that's fine, but we do need the declaration. Then you have to certify that you're complying with the procedures. You'll tell us about your voting, how many employees you have, who voted in favor, who voted against, who did not vote. That calculate button just tells you and tells us that a majority voted in favor of the plan. If a majority of your employees do not vote in favor of the plan, you're going to stop right here and you won't actually even be able to submit your application. You will have to acknowledge that you understand your legal requirements and that you will comply with them, and then you submit. We accept our applications on a rolling basis. They will continue to be approved. But if you want to be excused from the obligation to remit contributions for Q1 of 2021, you must submit your plan and receive approval by March 31st of 2021. So it's 30 days in advance of the final day that you have to submit your contributions to the authority. We have received about 6 applications so far, and are busy approving them, or reviewing them and approving them. If it's a complete application and there are no errors, so the declaration is complete, the private plan, the plain language guide is complete, then the application review process is really short and we can get that turned around quickly. If there are any problems, if the documents aren't correct, if the plain language guide has not been modified to meet your specific circumstances and you just give us a copy of what's on our website, it will be sent back to you. And so we really encourage you to take the time to make sure that the application is complete. Prudent employers who want to be excused from their obligations to remit the Q1 contributions should really get their plan application to us no later than March 15th. You can continue to submit them and we'll do our best to get them approved, but try and get them in as soon as you can. If you meet the application requirements, you will receive provisional approval, which means you don't have to give us your contributions, but you are on notice that you'll have to upload a final plan document within 60 days of when we issue the final filing guidance notice. If an employer fails to upload the final policy document within the required timeframe, or if for any other reason they don't have the private plan in effect in 2022 that they told us now that they're going to have, then the employer will be responsible for the 2021 contributions to the authority. And you can't collect those contributions retroactively from your employees. So you just need to pay attention to that. Plan approvals will be effective for 3 years. Unless you change your plan. So if you change your plan, you change your provider, you change any terms, say you think that you will be able to fund the plan entirely without employee contributions, but then you decide you need contributions, you need to get approval from your employees to make any change. So you need to educate your employees, hold a vote, and then reapply. If you have a self-insured plan, you'll be required to update your surety bond on a yearly basis so that we can make sure that the contributions match your current workforce. We do have the authority to deny private plans or to revoke private plans. If we determine that you provided false information or threatened or coerced your employees in connection with a vote, if you failed to pay benefits or you failed to pay them in a timely manner, if you fail to maintain the required surety bond, if there's any misuse of private plan funds or any violation of the statutes, if you're not providing benefits in accordance with the Connecticut Paid Leave Act, those are all grounds for denial or revocation. Failure to provide the reports that we require or providing false information to us or the insurance department would also be grounds for denial or revocation. Given you a lot of information and we will take questions, but if you have questions later or you want more information, please go to our website, ctpaidleave.org. We do have a lot of information on the website. We also have frequently asked questions that you can access, as well as videos. If you still have questions that aren't answered by the website or the videos, you can send them to us directly using our Contact Us page on the website. Contact us. You submit your question by email. You can tell us if you want an email response or a phone call back, but that is the best way to get the fastest information back to you. Okay, before I take your questions, let's just do a quick review. Don't forget things to remember. Register. If you haven't registered your business yet, you really need to do that as soon as possible. It won't take long. You go to ctpaidleave.org and click on the registration button. If you haven't started withholding your contributions, you really need to think about that because there's no guarantee that will give you a private plan approval. And if you haven't been withholding your contributions, you're going to be limited in what you can retroactively take from your employees. So you really want to, if you're working with a payroll provider, make sure the provider is doing the deductions. If you are handling it yourself, you want to start taking those deductions and hold them aside. If you're approved for a private plan, you don't have to remit those deductions to the authority, but it's good to keep those in a protected place in case the plan is denied or for any reason you don't hold your private plan through 2022. Educate your employees. Educate them about the program. Educate them about your private plan. And as I said, go to ctpaidleave.org for any additional information. We have updates almost every 2 weeks. So, make us a favorite, check back frequently. All right, I'm going to stop sharing my screen and see if any questions have come in. Amber, has anything come in yet? Amber? All right, I think we're having a little bit of technical difficulties. I'm not seeing any questions coming in the Q&A function. So if you do have any questions, feel free to put them in there. Otherwise, as I said, I think the things to remember are to check out ctpaidleave.org, check out the private plan page on ctpaidleave.org. In the applications that we've reviewed so far, the most common mistakes are failing to upload your declaration. You need to, if you have a fully insured policy, you would obtain the declaration from your insurance provider. If you're self-insured, meaning you're not purchasing a policy from an insurance provider, you need to complete your self-insurance declaration yourself. If you are self-insured, you do need to upload that surety bond with your application. We can't approve it without the surety bond, so that's something else to pay attention to. Amber, I'm having trouble hearing you, but I do see a question came in, which is, what if your employees don't vote for the private plan? Can you still apply for one? If you do not have a majority of your employees vote in favor of a private plan, then no, you will not be able to receive approval to offer a private plan. As I mentioned, the application process basically stops you at that point where we ask, how many employees do you have? How many voted yes? How many voted no? How many didn't approve? How many didn't vote? If you have less than 50% of your employees, 50% plus one, voting in favor of the private plan, you cannot offer a private plan, which means that you need to remit your contributions to the paid leave authority. Your employees will just apply to the authority for their income replacement benefits. I think the other question that we get a lot in context with private plan is, is this a way to opt out of the paid leave program? And it really isn't. It's an alternative way of making sure that your employees receive the income replacement benefits that the law allows. So the major premise is employees are entitled to receive income replacement benefits when they take leave under the Connecticut Family and Medical Leave Act. There are two ways for them to receive those benefits. One is to get them through the paid leave authority. The other is to obtain them through that private plan offered by their employer. So in both situations, the employees can be expected to contribute up to 0.5% of their wages. An employer who's offering a private plan can waive that contribution requirement if it chooses to do so. But no matter whether it's through the paid leave authority or through a private plan, the employees have to have access to the income replacement benefits. All right, I don't see any other questions coming in. What happens to employee contributions when they leave? So if an employee leaves an employer who has a private plan, the employer require the employee to fund the private plan, those contributions stay with the employer. They stay inside that private plan to help fund the private plan. They don't follow the employee. If an employee is in the public plan, they're remitting, or public paid leave authorities, paid leave option, and the paid leave trust. Their contributions go to the paid leave trust, and that is basically the pool from which all the benefits are paid. So the employee who is still working in Connecticut will be able to continue to access those benefits. If an employee goes from a private plan employer to an employer who is in the public program, the employee will start making contributions to the public program once they work for that new employer. Hopefully that answers your question. I think one way of thinking about the paid leave program is that it really is an insurance program. It's not a dedicated savings account. So the money gets pooled into the paid leave trust, or on a smaller basis, it gets pooled with the other contributions from the employees in a private plan. All right. I'm not seeing any other questions coming in. I know Amber's having some technical difficulties, but she has put some information in the chat about check with our website, ctpaidleave.org. Again, we do have other webinars that explain more about the paid leave program in general, about the changes to the Connecticut FMLA and how those interact with the paid leave program. So please do feel free to check us out. If you are interested in offering a private plan to your employees and have not already done so, you really do need to move quickly, because you'll want to obtain a private plan declaration of insurance. You'll need to educate your employees. You need to give them 2 weeks before you hold the vote, and you need to get the application in. We will accept applications after March 31st, but any application or any employer who's not received approval for their private plan by March 31st will be required to remit their employees' quarter one contributions to the authority. Regardless of what happens in the future, those contributions will need to be paid. New question that came in: are all employers mandated to sign up for this program? So as I said, all covered employers must register with the ctpayleave.org. All employees of covered employers in Connecticut have to receive income replacement benefits, and there's only two ways of doing that. One is to remit their contributions to the Paid Leave Authority, and we'll pay the benefits to them, or if they work for an employer who offers a private plan, then they will receive benefits that way. There is no provision in the statute to allow a covered employer to simply refuse to participate in the program, and there's no provision in the statutes to allow individual employees to opt out. If an employer fails to remit owed contributions and does not have a covered employer or does not have a private plan, then they may be subject to penalties and fines. So we really do want you to make sure that you either remit your contributions to the Paid Leave Authority or get an approved private plan. Just as a reminder, covered employers are all those entities who have one or more employees working in Connecticut. Unless you are the federal government, the state of Connecticut, a municipality, or Board of Education or private school, you're basically a covered employer. Okay, just waiting to see if anyone else wants to add any additional questions. Sorry, so yeah, just want to make another clarification. Oops. If you are a sole proprietor or a self-employed individual, you are not required to participate. You are not a covered employer, right? You are allowed to if you choose to, but you're not covered. So the thing that I want to focus on here is some sole proprietors are the business owners, but they have employees. So those employees need to participate. Also, if you set up your organization so that you are receiving a W-2 from your business, even though you're the only employee, but you set yourself up as an employee receiving a W-2 wages, as opposed to just taking a draw, then you're an employee. So even though you're the only one, you're still an employee. We do have FAQs on our website that get into this in more detail. All right, one other question. If you are a sole proprietor and you have no employees and you're taking a draw, right? You pay self-employment taxes. So you're not an employee yourself, but you later hire people, then you'll register as an employer at that point in time. We do have another question in the chat, which says, basically, if I have a payroll company, are they registering for me? The answer is sort of. Right? If you have a third-party payroll processor, they are registering all their clients so that they can remit the contributions that they are currently withholding on your behalf. They have some information, but not all of the information. For example, your third-party payroll provider is not going to know who you want at your company to be the contact in the event a claim comes in next year. So we do want employers to go in to ctpayleave.org and make sure that their account is set up and it's complete. But if you do have a third-party payroll provider, they will do this sort of basic registration to make sure that the contributions are being paid so that you're remaining compliant with the law. And if you have not yet taken deductions from your employees' wages, you do have a grace period. The Connecticut Department of Labor is allowing employers to make catch-up payments or take catch-up deductions from their employees' wages. Those catch-up deductions cannot exceed 1%, right? And you have to get all your catch-up deductions pulled and remitted to the authority by the end of June of 2021. So if you missed the first 2 months, basically you can take the next 2 months and take deductions of up to 1% so that you can get your deductions, the contributions made. You don't have to get specific approval from Department of Labor to take those catch-up deductions. If you have to go beyond the second quarter of 2021, so into July, you would need to get specific approval from the Department of Labor. We have a new question that came in, which is, what's the biggest downfall of going with a private plan? Great question. So I can tell you that the Paid Leave Authority's primary goal is making sure that employees receive the benefits they're entitled to, right? So we're agnostic as to whether they come to us and participate in the paid leave program through the authority, or if the employer is providing it themselves. That being said, I think it's important to know that having a private plan means the employer is going to be responsible for handling their employees' income replacement benefit claims. So, whereas if they're in the private plan, if they're with us, we'll be handling those claims for income replacement benefits. So there may be some additional administrative burdens associated with having a private plan. On the other hand, some employers already have an insurance company that's handling their leave management and say, look, we already have someone handling leave management for us, and they're willing to basically be our insurer as well. So it's just easier for us because it's all one spot. I think it's important to note that going with a private plan does not generally save the employer any money, because the employer is not the one paying for the paid leave benefits, it's the employee. So it's not a savings, it's really just a question of if you want to make the payments on behalf of your employee, or if you think it's easier to kind of have a one-stop shop for administering the leave benefits as well as the income replacement benefits. The other issue is, if you have a workforce that primarily has a lot of part-time employees or really mobile employees, they may not want a private plan because they may not be able to get benefits from their private plan. Whereas with the Paid Leave Authority, when we determine eligibility, we look at all of their wages from all of their Connecticut employers. So you could have employees who would be eligible for benefits from us because we're combining all of their wages, whereas with a private plan, they may not earn enough with that company to make the eligibility of the 2325. Okay. I think we've answered all the questions that I'm seeing. Just want to double check and make sure I haven't missed any. Again, if you have questions just about the Paid Leave Act or the changes to the Connecticut FMLA, I encourage you to check out some of our other webinars. We also have videos on our website if you just need information about how to register or how to apply for a private plan. We just have very short videos that are available to you to check those out. So ctpleave.org is the place for all of those answers. All right, I think we've got sort of going once, going twice. If anyone has any other questions, feel free to put them into the Q&A. If not, we'll give you 10 minutes back to your afternoon. It looks like a sunny day, at least where I'm sitting. So maybe you can go outside and get some fresh air before you go back to the rest of your activities for the afternoon. Thank you so much for joining us today. We hope that we answered your questions. We will be posting this video on our YouTube page, and you can check out other videos from other webinars. And please register. If you haven't registered, please register. If you're interested in a private plan, don't delay. Have a good afternoon, everyone.